I'm Henry Quillian. I'm here at Taylor English with my colleagues, and we're here to discuss things that are helpful in pursuing and defending lawsuits. But for those of you looking at the video out in the public, this is an effort to train people within our firm, but also as a public service to young litigators who may be starting recently out of law school and don't have much guidance. This is not legal advice. It's an effort to bring practical issues to your attention so that you can then do further research as to the resolution of the issues we raise. But we will be talking about our view of the rules as they play out in real life litigation. The topics for today are litigation holds and preservation of evidence, segregated billings for purposes of attorney's fees claims, motions to dismiss and the remedies associated with early motions to dismiss or motions for summary judgment that are brought very soon after the litigation has commenced, abusive and malicious litigation warnings, addressing early motions for summary judgment, and laying the groundwork for summary judgment utilizing early discovery in the process. So, for those of you that have been to previous sessions, we have gotten through the filing of the complaint, service of the complaint, answering the complaint, motions to dismiss, and all those preliminary steps that happen very early in litigation. One thing that we did not mention is what happens if a motion to dismiss is filed in response to the complaint. Does anybody know what happens under the Georgia Rules of Civil Procedure when that takes place? A relatively new rule causing a stay to take place in the litigation. Under Rule 911-12J, it says if a party files a motion to dismiss before or at the time of filing an answer and pursuant to the provisions of this code section, in other words 911-12, discovery shall be stayed for 90 days after the filing of the motion or until a ruling of the court on such motion, whichever is sooner. So that can affect discovery that is served with the complaint and the timing for response to it. And it also could affect the time period at which discovery terminates at the end of the discovery period. The rule doesn't expressly address whether that's extended or not as provided for in the Uniform Superior Court rules. But we have utilized that mechanism to slow down cases. Diane's nodding over here. We had a mediation, then litigation clause in a contract, and we were able to move to dismiss because the other party had never sought to mediate the case prior to commencing the action. So we moved to dismiss as soon as they filed against us. Turns out it got mediated and got settled. So that was a very helpful rule not to have the litigation going forward full bore while also mediating the case. Save the client money. Well, so either at the time you first have the matter walk into the office, or at the time you first get hired by your client to resolve issues in connection with a litigated matter, what duties do we have as far as making sure that evidence and other information that's associated with the underlying facts of the case does not disappear? Does anybody get input on that? Well, by the way, I know you're all eating, but I certainly do encourage you to respond. When in doubt, we're in the rule. Well, let me give you an example. A friend of mine, Lloyd Bell, just got a $2.3 million judgment up in Gwinnett County because the failure of a grocery store to preserve a video that was videoing the spot on the floor where the gook was that the plaintiff slipped and fell. And what happened there generally was they failed to keep the video from the surveillance camera, which happened to be pointed at the spot on the floor, and then it was going to be used to show how long it had been on the floor. Well, when the video was no longer available, apparently Kroger took the position that the video camera wouldn't have shown that spot on the floor anyway. During deposition of the gentleman who controlled that video surveillance, they got him to pull the camera up after he had already testified that it hadn't moved an inch since the time of the incident, and they were able to show live that it pointed straight at the spot on the floor where the gook was and where the plaintiff fell. The court struck the answer of the defendant and sent the case on the trial for only on damages, finding the defendant liable because they failed to preserve the video that might have shown whether the spill had only very recently gotten on the floor or whether it had been there for a long time. So it's our duty to make sure our clients preserve the evidence that might be associated with the case. And the way we do that is by crafting, and I do mean craft, not just simply spitting out, a well-lodged litigation hold letter to our clients, directing them to preserve all documents, to make sure that electronic evidence is not tampered with or altered, which may mean the involvement of other people at the client other than, for instance, the general counsel, such as the IT personnel and other people who can make sure that electronic evidence is not improperly destroyed. And of course, that you need to take into account the fact that some companies have automatic document destruction programs that are in place and will continue to be in place unless they are stopped. And the last thing you want to do is find out that the evidence for your case, either defending it or if you're the plaintiff, the evidence that you intended to use to prove your case got destroyed in some sort of document management program, because the courts do not like that at all. And for you attorneys out there, they put a huge burden on the attorneys to make sure that nothing bad like that happens. In fact, there are a slew of cases coming out where attorneys get severely sanctioned for allowing their clients to make the mistake of destroying evidence, or alternatively not producing evidence, particularly electronically stored evidence, because the attorney doesn't know enough to know where to look, because they never asked the right questions of IT personnel, etc. So, for instance, there was a case where an attorney did not know that automatic backups were made, and so that they never looked to see in the automatic backup spot if the requested information was there, and when it was later found that the evidence did exist, the attorney got badly sanctioned by the court, and the client, of course, to be sanctioned as well, which puts the attorney in a very bad position, such as having the answer stricken or something, or the complaint dismissed or something like that, because of failure to properly preserve and produce evidence. So, we won't go into all the details of a litigation hold letter, but just know that's something you need to do very promptly upon learning of a litigation dispute. And with more and more emails involved, voicemails, which I've recognized have a tendency to go away in thunderstorms and things like that, sometimes you need to take extra steps to make sure your evidence doesn't disappear unexpectedly. Because one of the goals of this seminar is try to avoid all those things that you would otherwise have to fight about in litigation by taking proper steps up front, so you don't have all those extra fights in your litigation. You just get to the issues at hand and try to get the case resolved for your clients. Now, one thing that is sort of near and dear to my heart is, if I'm the plaintiff, I want to be able to potentially recover attorney's fees, and there are only a limited number of ways to do that. If I'm the defendant, I may want to, if I believe it's a frivolous litigation, might want to preserve my right to recover attorney's fees. And if I'm a counterclaimant, I want to make sure I can recover attorney's fees on my counterclaim if the law is available to do that under that particular counterclaim. And one of the things that this general rule for damages in Georgia is you have to be able to prove your damages with a reasonable degree of certainty. And although attorney's fees are looked at different ways in some under several different cases, generally there are damages, and so you can't just have a speculative display of attorney's fees when you ultimately try to recover your attorney's fees. Also, as a general rule, you can only recover your attorney's fees associated with certain types of claims. For instance, under OCGA 13611, you can only recover attorney's fees for affirmatively pursuing a claim that is ultimately successful. So if you have all your time spent working on a counterclaim or the defense to a counterclaim mixed in with your attorney's fees that you spend pursuing your claim, you're going to have a huge mishmash when it comes to trial as far as proving what your attorney's fees are. So when a case comes in, once the pleadings are joined, you ought to very early on consider, should I set up a subfile for billing various elements of the case? Also, if you have a very straightforward claim, you believe you can get, for instance, 13611 bad faith attorney's fees recovery for relating to a breach of contract claim, for instance, and then you have some cutting edge miscellaneous claim that you think you have a reasonably low chance of recovering on, but it's possible, you might well consider segregating out your affirmative claims into various attorney's fees billing files, so that when it comes time for trial, all you have to do is spit out your bills for your various submatters, and you'll already have your attorney's fees segregated, because otherwise you're going to have to go painstakingly through sometimes lump sum billing and assign little elements of time to each activity, and it takes a tremendous amount of time at the end of the case. It could have been avoided if you work on it along the way. Anybody got any questions or comments on that? Anybody had any success segregating out your fees and recovering them? Well, I have. and believe me, it's a lot better to have them already pre-segregated than it is to try to break it out, because then ultimately you're going to have to testify regarding those fees, and you want to be on really solid ground, because frankly you're likely to be the one cross-examined about whether the fees were reasonable and necessary for the work you're seeking recovery on. So you don't want to be in an unsure position. You want to know, we set up this procedure early on, we tracked the fees appropriately throughout the course of the case, and when it got to the end of the case, we knew which fees were associated with which claims and which fees were not associated with those claims, such as defending a counterclaim. Okay, if you obtain a case as a defendant and you believe the case is totally without merit, let's say they sue the wrong person entirely, and your client has nothing to do with this case, are there any mechanisms you can use to preserve the right to recover or potentially recover attorney's fees down the road? The answer is yes, there are statutes. Y'all come on now. OCJ 915.14. Has anybody used that? Okay, we got a couple of hands up back here. What do you use it for? What is 915.14 supposed to address?
Frivolous litigation behavior, assertion of frivolous claims and defenses, an approach to the litigation, even in a non-frivolous litigation, that is designed to unnecessarily expand or delay the proceedings.
Very good.
Damages are attorney's fees and costs of litigation.
And the damages are, just in case that was not heard on the video, damages are attorney's fees and expenses of litigation, right?
Reasonable.
And expenses of litigation can include expert witness fees, etc., if they're necessary to repel the frivolous claims. Yes?
If you have to liquidate retirement accounts, in order to pay attorney's fees, and you have $70,000 that you paid in penalties to the IRS in order to get to that money. Is that included in something that you can recover?
Arguably.
The basic question is whether consequential damages as a result of suffering the attorney's fees are recoverable, and I don't think I've ever read a case that says that. I sort of doubt it.
I think what you have to do in that context is not use 915.14, but instead use 51.784, I think it is, which is very similar, but allows for damages beyond attorney's fees and expenses.
Okay, Mr. Pendergrass has brought up exactly the next topic, or the corollary topic. We're talking about things you need to do early on in the matter. As soon as you identify, in this instance, a frivolous claim, in order to preserve your potential right to recovery of attorney fees and expenses down the road. Under OCGA 915.14, do you have to send any sort of notice when you have identified a frivolous claim that you're either defending against, or if the other side, do they have to identify the fact that you have served a frivolous claim against them in any way?
I don't think so.
The answer is I don't think so, and Mr. Jones is correct. I'm not saying it's a bad thing to let the people know early and often how frivolous their matter is, because that tends to bode well for you when presenting your claim down the road. Judges tend to like the fact that somebody said, I told you once, I told you twice, and here I am, I'm telling you the third time, and this time I want to get paid for it. But there's no legal requirement under OCGA 915.14 that a preliminary notice be given to warn the opposing side that they are pursuing frivolous claims or defenses. And under 915.14, a frivolous defense raised by a party may also be sanctionable, as well as Mr. Pendergrass pointed out, unnecessary expansion of the litigation can also be sanctionable conduct.
Call me Craig.
But I'm trying. You're going to be on the World Wide Web. You need to know. You need to get a little attention there. But as he pointed out, there is a set of statutes, OCGA 51.780 at SEC, which under 51.784 has a specific requirement regarding sending a notice letter to all parties whom you claim are pursuing litigation that is frivolous or causing it to be pursued. And I believe the word is participating in the frivolous litigation. For instance, if you have a husband and a wife team, maybe the husband's the only plaintiff, but it's the wife who's coming up with all the ideas and encouraging the husband to pursue frivolous litigation. That notice should be sent to the wife as well as to the husband, because under that set of statutes, OCGA 51.780, you can pursue the parties that participate in pursuit of the frivolous litigation, not only the opposing party. Now, what does that notice need to include? Mr. Devine?
You got to specifically point out what it is you think they're doing that's frivolous and make a demand that they cease and desist. It's essentially a codification of the old common law abusive litigation tort. So you got to put them on notice that you're making that claim, and they have, I think, 30 days to cease and desist. Or you can later, after the litigation is totally concluded, you can file a separate lawsuit altogether under that code section that would seek not only the attorney's fees and expenses of litigation, but consequential damages, which would go to the earlier question about having to liquidate, say, retirement funds in order to, and pay taxes in order to have the funds to pursue the claim.
Okay, we have another question.
So if the person that's causing the frivolous litigation is a purported expert, Is this the path you go to make sure that the purported expert?
Basically, if you, it'd be worthwhile doing what if you're in doubt? Reading the rules, right? But I believe the statute broadly paints the picture. Of course, you have to show very specific conduct in order to, in fact, I think it's malicious conduct in order to recover under 51780. But
if you have an expert that testifies for this particular lawyer and you can prove it in other cases, is that sufficient?
Could be.
the people that participate in the abuse of litigation, if they undertake the tortious acts and use the mechanism of litigation to pursue those tortious acts, could be liable. And so the appropriate recipients of this letter are possibly the attorney for the other side, individually called out as a potential future defendant separate and apart from their client, the opposing client who you think may be coming up with the false facts or whatever it is that's giving rise to the frivolous litigation, third parties who are encouraging the litigation, and this notice has to be sent to each of them individually, and it has to be sent by what kind of mail?
Certified return receipt.
Certified return receipt, and it needs to set forth everything that 51784 says has to be in there, which is pretty detailed description of the offending conduct and to the extent possible, I guess, how it's damaging the person that's who's sending out the letter.
And what about if the expert witness has an attorney and that attorney has represented this expert witness in other cases involving the attorney for whom she testifies regularly? Would that attorney be also possibly subject?
I think you would have to evaluate the case on a. Basically, the question is if there's an attorney involved with a party, and if the attorney has knowledge of improper conduct in another litigation that's being carried over into a new one, or if there's perhaps because of the attorney's prior involvement, they know that the person testified completely oppositely in one litigation versus this one. I think you just have to evaluate the case like you would any other case. You'd have to go through the statute, see if all the elements of the cause of action are there. But initially, the 51784 letter is a warning. It gives the other side a safe harbor if they withdraw the offending conduct, withdraw the claims, dismiss the claims that are associated with the offending conduct. And then after that, they're sort of at risk. If they go all the way through the litigation, cause a lot of damages, run up a lot of attorney's fees, then they can be subject to sanctions. So the general thought here, however, is you need to have this on your checklist of things to do for evaluation, and then probably before you send out one of these letters, don't just whip it out and start sending them to people, because they're people do not like to receive them. And you never know if your client's telling you the truth on everything. You probably ought to seek counsel of a colleague and really have a heart-to-heart with your client regarding whether this is a good thing to do, because it might start World War III when all you really have is a little skirmish. So it's not to be done lightly, but it's just something that ought to be on your checklist to consider, so that you don't waive the opportunities that you might have down the road to address these issues. Anybody got any further comments on that?
One other thing on that statute is it's a separate cause of action that has to be brought after the litigation in which you're contending abusive conduct is going on. That original litigation has to come to a close, be finally closed before you can initiate the new cause of action. And the new cause of action has a 1-year statute of limitations.
Yes. Todd?
Yeah, and in follow-up to that, 13611 you bring in the existing case, and 91514 you also bring after the case is over, but you bring that by motion.
Right.
Or you can now bring it within, before the case is over. Used to be that you had to wait till the end, but now you can bring it at any
You
time.
can assert it.
You can assert it.
Now, and to sort of summarize here, let's go through step by step. Under 51-780, that is a separate cause of action brought after you conclude the original litigation. By the way, you have to win on the points that you contended the other side was wrong on. So you have to succeed in proving your case or successfully defending your case to show that they did not have an appropriate claim, and then in a subsequent case you have to pursue a claim saying that they maliciously were pursuing you with this frivolous claim. And as Foy said, just in case it didn't pick up, there's a 1-year statute of limitations on that. Under 915-14, used to be perceived that you had to wait until after the litigation concluded. In other words, you successfully got motion for summary judgment granted, or you got the case dismissed, and then in that same case you would file a motion under 915-14 seeking sanctions for the improper conduct. Now, however, I believe those motions can be made at any time during the course of the litigation. So that would be one means, for instance, of giving the other side notice that you intend to pursue sanctions against them for pursuing a frivolous claim, is go ahead and file a motion against them. I don't know if the judge rules that it's premature, whether that would ultimately or otherwise rules against you, says this is not frivolous, and then it turns out you win it at the end of the day. You might have sort of messed up your ability to recover at the end. Brian, you had something?
Yeah, from a philosophical standpoint, I've been at firms or at litigation groups where frivolous litigation letters had to be cleared by someone given the significance of a letter. Is that something you do here?
As I stated earlier, I'm not sure Taylor English has a policy regarding sending frivolous litigation letters. But I do think it's a very wise thing to bat it around with a number of colleagues, make sure it's the appropriate thing for the circumstance, because it is something you would rather not participate in too much during the course of your practice. Save it for the worst conduct by the opposing parties.
Henry, I want to talk about kind of the interplay between 51-780 and 915-14. I think there have been some recent cases that have talked about where one stops and where one continues.
The question is, what are the differences between 915-14 and 51-780? Is that correct? Well, let's put it this way. I know that there's a distinction in that under OCGA 915-14, your sole remedies are attorney's fees and expenses of litigation. You cannot get any extra damages.
And they're determined by the judge.
They're determined by the judge. And under 51-780 at SEC, you can get attorney's fees that were incurred in the previous litigation. You can get your expenses of that previous litigation, and you can get the damages caused by that previous litigation. And frankly, you might be able to bring a 13-611 claim in your subsequent 51-780 lawsuit and take advantage of the bad faith prong of that statute to get your attorney's fees in the subsequent litigation, because you would think if you proved malicious litigation had taken place before, that would be bad faith conduct that would be subject to potentially recovering attorney's fees in the new litigation.
This might be famous last words. I also think there's some recent cases that say if your sole damages are attorney's fees and costs from your underlying litigation, your exclusive remedy is 915-14 instead of 51-780.
I think that's right. And also the determination of the facts can be a jury in the 51-780.
Okay, so under 51-780, you would have a jury case. However, I suppose what Matthew is saying is that if you only have attorney's fees and expenses of litigation, then your 51-780 claim might be frivolous in and of itself because you don't have any other damages. I don't think I've read that case. I'm not saying it doesn't exist. What I do know is if you bring a 915-14 claim, you waive your ability to bring a 51-780 claim. I think you're precluded from bringing it subsequently if you've already sought.
Yeah, if you had it heard and resolved in that first litigation, then that's raised judicata.
Right. So we have these are, as I've discussed, we're not trying to go into every detail of how everything plays out. That one was pretty thorough in that regard, but what you do want to do is lay your groundwork to assert claims if you're going to need it, including doing the business side of the coin, which is segregating your attorney's fees and your expenses in between your various claims and or defenses, so that you'll have your evidence, just like you're developing evidence in any other manner. You'll have your evidence of your attorney's fees and expenses that you need in order to assert those claims at the end of the day. All right, so what happens if you're a defendant, plaintiff sues your client, and well, you're the lawyer for the defendant, and you think that you can get rid of the lawsuit expeditiously based on what the plaintiff has pled, and for instance the contracts that are attached as exhibits to the complaint. What are your options as a defendant as far as going ahead and trying to get rid of the case?
Motion for judgment on the pleadings?
You can make a motion to dismiss, motion for judgment on the pleadings, or you can make what kind of motion?
Summary judgment.
You can make a summary judgment motion. And if you were relying on something outside of the pleadings served by the plaintiff, and you filed a motion to dismiss, what happens to that motion?
Converted to a motion for summary judgment?
So it converts to a motion for summary judgment. Does that mean you have to do the statement of undisputed material facts and the theories of recovery when you do that motion to dismiss? Sort of, maybe. Let's put it this way, if you do have to do it, people get away without doing it, I think, all the time. But, and so let's assume you are the defendant, you're representing the defendant, you did make a motion to dismiss, and you'll say you attached an affidavit in addition to relying on what was included in the pleadings that the plaintiff had served. And your affidavit related to subject matters that the plaintiff had no knowledge about. What options would the plaintiff have in responding to your motion, which will be turned into a motion for summary judgment, for which they had no currently available response, as far as being able to raise genuine issues of material fact because they don't know the information themselves?
Move for discovery under Rule 56.
Okay, under 91156, which subsection?
I knew you were going to ask me that.
When in doubt?
D or F? D or F?
It's F. Under Rule 91156F, when a party has that motion for summary judgment moved against them, and they do not have available evidence that they believe might actually exist to contest the motion for summary judgment, I'll just read it. Should it appear from the affidavits of a party opposing the motion that he cannot, for reasons stated, present affidavit facts essential to justify his opposition, the court may refuse the application for judgment. In other words, the court could say, come back again later. I'm going to put this motion for summary judgment aside, or may order a continuance to permit affidavits to be obtained or depositions to be taken or discovery to be had, or may make such other order as is just. And so that would be the remedy of the person who all of a sudden has a motion for summary judgment against them, and they're basically caught naked because they haven't done any discovery, can't raise genuine issues of material fact. They would move under 91156F. Now, what does 91156F require of the movement?
An affidavit
An affidavit saying what?
saying that they're not able to respond at this time to any discovery.
Right. I had a case where my client got sued. We immediately moved for summary judgment within 30 days of being sued. The court, the other side, moved under 91156F. The court allowed discovery, which went on for 6 months at least. I can't remember whether we had an extended discovery period or not. 3.5 years later, the court granted the summary judgment that was filed immediately on the exact same grounds as had been sought, which was a question of law, we believed. And that was 1.5 years after oral argument on the motion for summary judgment. So there was nothing that could be done about that. It was incredibly sad because the client had to litigate, go through all that discovery and everything, even though they had a dead bang winner right from the very beginning. In that particular matter, it actually went up on appeal and then it got settled in a mediation. But would we have had potentially some sort of claim under 915.14 or under 51.780 as a result of being sued in that case?
Yeah.
Would you notify the judge? If it's the judge, judge waited three years to rule on a motion?
Yes. It took forever.
Welcome to the world.
Yeah, so for those people out there, the courts don't always act as fast as you would like for them to. But that one was a ridiculously long situation.
Henry, was the discovery limited to the issue in the affidavit, or was it discovery on the whole case?
Discovery on the whole case. And it was a situation where there were about 6 defendants, so it was even worse than, it was everybody fighting against everybody else, and everybody had to be at every deposition and all that. It was bad. So just remember that if you get caught off guard like that, you do have and don't have every bit of evidence that you think you need to prove your case because you're expecting to get it from the defendant. If you're the plaintiff and they immediately move for summary judgment against you, then you have the 91156F option of seeking the ability to get more discovery to contest the motion.
Why did you file a motion for summary judgment instead of a motion to dismiss?
Because we had to use some outside evidence. I can't remember exactly what it was. But it was, the pleadings just stated this claim, and we said, well, it can't be that because. And I believe this is a question of whether there was an easement on property for a pipe. And this is a pipe that had been installed in the late 1800s or whatever. It wasn't shown on any surveys or anything. My clients bought the property without any knowledge of it whatsoever, and the other side was contending a right to use the pipe to go across the property. So,
have you seen situations where you've successfully been able to argue a summary judgment that early in litigation? In other words, you couldn't do a motion to dismiss because you had to bring in other evidence, and yet you were able to get it thrown out without discovery?
It depends on the circumstances. Foy is probably familiar with this. For instance, if the defendant has a preemption defense or something like that, which may be purely a matter of law, then an early motion for summary judgment might be granted sooner rather than later if the court ever gets around to it. As we all know, discovery might go this entire course before the court ever picks up the motion for summary judgment. But it doesn't hurt, sort of along the lines of giving notice to the opposing party that you think they've got a losing case, to go ahead and figure out what your case is going to be and move for summary judgment. Boy, you had something to say?
I was just going to say, there's broad discretion in that provision that gives the court the ability to let you do your discovery before you have to respond to the summary judgment motion. So, and it's probably not going to be reversed on appeal except in abuse of discretion. So, the only situation where I'd see where you might be successful in beating back something like that is if you've done a whole discovery period and maybe an extension and the other side hasn't taken any discovery. A trial court might say, I'm not going to give you more time for discovery. You have plenty of opportunity for discovery. I'm going to go ahead and rule on this.
The other thing that's quite possible, and if you're in a rural county somewhere, the judge may say to the plaintiff against whom a motion for summary judgment has been brought, They won't say it, but they'll think, well, that's my buddy, and I'm going to grant summary judgment. You should have had the evidence before you brought your case. Just a real world possibility that a judge would rule against somebody because procedurally it would be correct if the person doesn't have any evidence to contest or to raise a genuine issue of material fact. They could go ahead and grant summary judgment. But that might give rise to abuse of discretion, as Foy pointed out. But I believe he's correct that that would be a very broad. On appeal, it'd be very hard to get it reversed. The Court of Appeals would have to find something bad happened.
I have a memory, and I think it was in the case law if it wasn't in the rule itself, but same exact situation. You've got a summary judgment motion filed. You haven't completed your discovery on that issue yet. It's early in the case, but there was it was either in the rule or in the case law that you have to basically respond to that 56F. No, your 56F motion has to lay out affirmatively what discovery will prove, not what it might prove. And I found that to be very challenging because if you don't know what's out there, that you can't speculate. Like perhaps if we were to depose this person, they would say this, or we don't know what's out there. It's like you've got to, in that affidavit, basically say, if we're allowed to conduct discovery, the evidence will show that. And in an affidavit under oath, you don't often know what the evidence is going to show.
Well, there may be a case that would be surprising. The person definitely has to submit an affidavit, stating the reasons why the extension of time or additional discovery should be taken. For instance, if the question is what are the terms of a written contract and the plaintiff signed the contract but only the defendant has the possession of the contract, and the plaintiff hasn't been able to get it in discovery and the defendant moves for summary judgment, then it would seem that it would be impossible for a plaintiff who can't remember exactly what's in the contract to state what's in the contract other than generally that they believe will be proved. How do you
That was actually almost the identical factual situation where it came up for me, is that it was a breach of contract issue, and our client thought that the plaintiff had produced a forged or altered contract from what the original had been, but our client had lost his copy. And so he wanted to conduct discovery on, just to figure out that this was actually a legitimate version of this contract. But he didn't know for sure. And it was all based on his memory that it just didn't look quite right. That wasn't the terms he remembered. And based on that, we lost that 56F because he couldn't swear under oath for sure that discovery was going to show that that was a tampered document. And I think Rachel has had a similar issue come up on 56F too. So.
Well, has anybody else had the 56F denied on the basis that you couldn't swear that what somebody else is going to testify? I don't really see how that can be the case. It sounds bizarre, but I'm not saying a judge wouldn't do it, but it seems like an unreasonable burden because essentially you're saying, I know that if I depose this witness, they're going to say this. That makes no sense. That's contrary to your normal course of conduct.
That's why I found all that very frustrating.
Well, let's hope that doesn't happen to us. Okay. Along the lines of this, let's say if your suit is now joined, got the complaint and the answer. We're not going to talk about third-party complaints and all that right now. What should be some of the first things you start thinking about as an advocate for your client regarding getting the matter resolved? Maybe you think about where the weaknesses are in your case and where the weaknesses are in the other case, and what discovery you would need to either undermine, if you're the defendant, undermine the plaintiff's case, or if you're the plaintiff, what discovery you need in order to get to that golden ring at the end of the rainbow. So you need to start laying out your discovery. And this, we talked about discovery potentially serve with the complaint in the first session. Maybe it was the second session. But this would be this would be all that discovery if you had not yet served discovery, if you're the plaintiff, plus discovery that would address the affirmative defenses raised by the defendant, for instance. Let's say that the defendant sprays out a whole panoply of affirmative defenses, alleging all sorts of things like payment, estoppel, etc. What kind of interrogatories could you ask if you wanted to ask it in interrogatories instead of in a deposition that could be used to overcome those affirmative defenses?
State each and every fact in support of your
Contention
defense.
interrogatories.
Update.
Right, you could ask contention interrogatories, sort of reciting back to the defendant the affirmative defense they claim they can prove, which sometimes strikes fear in a defendant because they sometimes spray out those affirmative defenses and just lay them out there without having a single fact to support them, which makes the discovery very uncomfortable to respond to. Similarly, if you're the defendant and there are allegations in the complaint that you think the plaintiff really doesn't have any evidence to support, you can ask interrogatories directed to individual allegations in the complaint. And of course, how many interrogatories are you going to have under the Uniform Superior Court rule?
40.
It's 50, including subparts, right? And subparts are looked at very differently by different judges, but you don't necessarily want to use up all your interrogatories in your first round, right? But so therefore, rather than just asking interrogatories on miscellaneous non-material allegations that aren't ultimately going to lead to potential summary judgment on your behalf, you would want to focus your interrogatories on getting to the issues that will potentially lead to summary judgment on your behalf. And that takes some analysis. I often wonder why people just, and I assume it's for cost savings, just attach a standard set of interrogatories and send it out with a whole bunch of interrogatories. Let's say it's a breach of contract case between two construction companies, and they ask all these interrogatories about your medical bills, etc. Makes no sense. Because there are no medical bills involved, you wasted the interrogatories. Okay, how about requests for production? Is there a limit on the number of requests for production you can make on another party?
No.
No limit, except what?
Same reason.
What would be the limits on asking requests for production?
To be overly broad.
Well, they could be not well enough tailored so that you're going to get objections to everything, right? Or if you ask 450 requests for production, then you're likely to get a motion from the other side, to the court saying, this is ridiculous. This is, these are just shotgun approach. We shouldn't have to respond to all these. Even if they're well tailored and it's a very complicated matter, then maybe so. But if it's just asking for anything and everything from the other side, that's going to cause the responding party to spend endless hours, drafting objections and such. Arguably, that would be a conduct that a court might want to contain. So that would be the limit on the request for production. How about request for admissions? No limit on request for admissions. What's a good practice for asking requests for admissions? Do you want to ask them that are like paragraph at a time? You need to ask for individual facts to be admitted, or factual conclusions, legal conclusions based on individual sets of facts. What would be how would you make the decision about whether to take a deposition instead of asking interrogatories? What sort of factors would go into that determination?
Well, the attorney's going to answer the interrogatories, so then just the interrogatory puts them on notice and gives them 30 days to figure out what their answers are. A deposition often is much more effective in getting the witness to catching them off guard and getting them to give you a
Especially on those contention interrogatories, because depending on the circumstances of the case, if the opposing party is being deposed and you're asking them for all of the information they have that would support a particular allegation, and they're not well prepared and they don't have anything, while it may not necessarily foreclose them from coming forth with further evidence, it certainly puts them in a bad position.
So the proposition is that if you're trying to close doors on the party that you're deposing, you might go ahead and depose them early rather than asking contention interrogatories, because the lawyer is going to be able to sit back and scratch his thumb and go dig through papers and documents and come up with something to say, perhaps, in response to the contention interrogatories, whereas the representative of the company may say, I don't even know what you're talking about, I don't have any information on that.
It seems like no matter how well you craft an interrogatory, there's always a cagey way to respond to it. And so, getting someone on deposition seems like a more effective way to get true testimony. It also sizes them up for how they're going to present the trial. And that's pretty important stuff to know, too.
But I find when you ask those types of questions in a deposition, they're like, I don't know, that's, my lawyer put that in the complaint. I mean, it makes them look foolish, or you get an objection, even worse. The lawyer won't let them answer that question.
Well, the other thing is, once the witness has read a lot of interrogatory responses crafted by their lawyer, if you thereafter depose them, during the time they're reading those interrogatory responses, they're probably thinking, yeah, that's the ticket on that one. Yeah, that's how I responded. They may come up with all sorts of ideas they never dreamed of having regarding the facts of the case. So sometimes I think it's very effective to notice a deposition, especially in a fraud case or something like that, where you've already got the goods on the other side, before they have a chance to go through piles and piles and piles of documents and figure out some sort of cockamamie story as to why this came about, to take a video deposition with them of them very early on, possibly notice served with the complaint, and just hammer them with cross-examination that they really can't thereafter weasel out of. But one where basically what your goals early on in the case would be is finding the weaknesses in the other side's case, establishing facts necessary to obtain summary judgment so that hopefully you can cut the litigation short. Otherwise, get testimony that's either so embarrassing or whatever for the other side they'll want to settle it. But of course, you don't want to go outside the bounds of reasonable discovery when doing so. So my point of the matter is if you, with respect to this entire subject matter, if you take steps early in the litigation to focus what you want to do rather than just doing it step by step in some sort of rote matter without thinking about what your plan is, you're going to end up probably reducing the total amount of litigation that goes on, and also save yourself a lot of headache down the road, or possibly your inability to pursue claims if you have failed to lay the groundwork for those claims. Any other comments on the subject matters today?
And I don't know if you covered this or will cover this. There's often a distinction between federal court and state court. I know in federal court you can file a motion to dismiss and not have to answer at the same time. You can wait for a ruling on the motion to dismiss. My understanding in Georgia has always been you have to answer as well as move. If you move to dismiss, you also do have to answer within the prescribed period. And so I've known people who have practiced almost exclusively in federal court, and they get a state court case and they move to dismiss and they don't answer, thinking the rule is the same in Georgia when it's not. So that's a trap.
Right. We covered that the last time, but it always helps to be reminded that the focus of this particular set of discussions is on the Civil Practice Act, but we do want to always be aware of the distinguishing points that can end up being a trap under the Civil Practice Act. And so the answer is you better have a lock, shut, absolute positive winner if you move to dismiss in Georgia and you have not answered.
You gotta answer.
But you better answer under any circumstances. I've never failed to answer in Georgia.
And on the attorney's fees, I know that in federal court, you can bring a 13-611 claim, at least in a diversity case, and I've won attorney's fees in federal court under 13-611, but 915-14 is not available to you in federal court.
Actually, that's Mr. Jones has made a wonderful point. 13-611 is a substantive law in the state of Georgia, which allows you to bring that claim both in state and in federal courts, whereas 915-14 is somehow construed to be more of a sanction law, a civil practice type law, I guess procedural, so that doesn't apply in federal court. Federal court has what? It's got Rule 11, which is similar but different.
51780 is a substantive claim under Georgia law that you can do in federal court, I would think, under diversity.
Just in case, that the 51780 does appear to be a substantive tort law, and I guess if you had the requisite damages, etc., for diversity jurisdiction in federal court, unless the statute says otherwise, which I don't think it does, you could pursue it in federal court. Has anybody ever seen a federal court 51780 action? Has anybody, I think there are very, very few 51780 actions that have been tried and appealed.
There are. Yeah. It's a relatively new statute.
And it's very hard to win. You have to prove a whole lot of things, and I imagine they tend to get resolved somewhere along the way.
Yeah.
Okay, well, thank you for your participation.